objection or has concerns over the still image. I understand that might be in a little bit of a different category, but in terms of question number 5, and I'll just, while I have the floor, I'll just go through what they are. The FBI aerial with all person of interest marked, that would appear to be the defense exhibit that they neglected to mark and has now been accepted. The state also has one, which is Exhibit 25, which has Mr. Rittenhouse and Mr. Rosenbaum marked, but not the Zeminskis. So I assume they mean the defense exhibit, but we could send both back or have them come down and view it, however we do that. The drone video is 73. That's the full unedited exhibit that's been in evidence now for over a week. The zoomed in still image, we all have talked about that and beaten that horse to death, so I'm going to skip that for now. Then the full event video in regular and slow motion, that seems to be the drone video, as that is the only video of incident 1 that was played in slow motion, just as the only video of incident 2 in slow motion was Dr. Black's. So their expert video was submitted. Our expert video is, I believe this is actually 6 videos that they're asking for, which is the drone video. It's spliced out, so it shows the first third of the incident, the second third, and then up until the end of the shooting, and it's in regular and slow motion, and that's exhibits 581, 582, 583. I'm sorry, S81, S82, S83, S84, S85, and S86. And we believe that the jury should have full access to them. They should have full access in this room. And that's our position. I do not believe a technical reality, shall we say, or an unknown technical incident should result in a mistrial.
How would we object? Pardon me? How would we object to something we didn't know existed until it was over?
I didn't find that point particularly persuasive because, but anyway.
It's impossible for us to do that. And if everybody in this room that's a lawyer has been a prosecutor. Your job is fairness and being a truth seeker. It's not debatable that it's not fair what happened. We can sit here all day and say it's been played. We didn't know there was another version. How is that reasonable?
Well, I persistently warned the state that, there's a day of reckoning with respect to these things. My feeling is I had my qualms and I decided, well, I'll let the jury hear it. I think I made the comparison the other day of the breathalyzer, where the officer doesn't have to be familiar with how the breathalyzer does the analysis, but that's a device that has been sanctioned by the courts, and I just don't think we're at that place with this, and particularly if they've got evidence. I didn't see that in your motion about the manual.
We've learned it since I filed the motion.
Well, if they've got the manual, I don't know. It may be. I forewarned you. You've pressed with this, and that's fine. I've let it in, and my view on it now is where we are. We might as well follow through with it. And if they've got everything correct and it's reliable, then they won't have a problem. If it isn't, it's going to be ugly. All right.
I would just note that the defense, I'm assuming they were paying attention to the trial, would have known on Monday when Detective Entramian testified that that version was different.
We're going to talk about it later because I've made the decision. I'm going to be played. You've suggested that it be played here in the courtroom under whose supervision?
This becomes the deliberation room for that portion as they watch the video.
I'm going to be in the room with them.
The same people that are in the room with them now.
Well, why come down if they're just going to be looking at? I mean, are you saying that they come down in here with all of us in here?
No, I'm saying everyone leaves.
Okay, well, why not just leave them up there?
Because the screen, watching it on the screen that,
I got you.
And that goes, the problem we're talking about on 5 early is the request 5.
Yeah.
We're talking about the
I didn't
problem.
know the last word you said.
The problem we're talking about on request 5 is on the front end so far. And it goes to the same thing with that television, adding the pixels on the back end. So now they're looking at it on a computer upstairs, and I don't know why they're not looking at this on a computer. Meaning 5. I put my hand on request 5.
Well, and how many times? One time? Is that what you said?
I didn't know. I think just as they're, no, I think they should be free to look at it as much as they'd like.
Well, that would be my bias, frankly.
We've laid out.
But we've got the law that you cited the Anderson case. I have ruled in the past, and I'll rule again. The Anderson case is not applicable to images of the event, only to like statements and that types of thing. So, but I'll hear you out.
Judge, I'm relying on a Supreme Court of this state's case. I understand that you're separating them, and I'm just here to tell you that we object to it being played over and over. What I've learned from your case with the videotape or the cassette tape and Anderson, both of those cases talk about not there being an overemphasis on specific parts of evidence.
Possibly overemphasize a video of something, unless I suppose if it's not an accurate video, I suppose then you could. But then you're overemphasizing it when you see it the first time.
That has been the concern of the court in having the jury have just unfettered access to it. In Anderson and in I think it's Franklin, that was part of the concern in both cases.
And I will repeat, I think it's the fact that we have to censor what the jury uses to decide. When the founders of the country gave them the power, it has to be censored by the judge. That's really insulting. So I'm not going to say there aren't cases where a jury could overemphasize something, but for me to say, well, there's a video that is purportedly an accurate depiction of what happened, and you can only look at it so many times, I'm not going to do that. So they know the risk, and they've assumed it, and so they can watch it. They'll do with it as they see fit.
Judge, I understand the ruling in the videos. We do not object if the zoomed-in image is not sent with them. 155.
Well, I'm going to leave you gentlemen to confer, and as you did before, and came up with a workable.
How do you wish? Should we put it on a drive and send it to the jury, or are they coming down here?
Why don't you give them a drive, because then they've already got the clean computer to work with to put it on a drive.
You want to use this?
And then they'll come down here, and presumably they know how to work it, or if they haven't told us they can't. They can come down here, and they can operate it from wherever they're comfortable, and we'll all clear out of here. And okay?
I will work on that.
Okay, you confer and come up with an agreement to which you object. A working agreement to which you object. Now let's do the case of the state against Emmett Zier.